J. Solello presiding.
Please be seated. He is now with us, Mr. Shaw.
Thank you. Good morning. Again, I too would like to thank you for your service over the last few weeks. I know it's been a long road that we've been on together. I know you've all sacrificed. I know there are all places that you'd rather be right now. Again, this is one of the most fundamental rights that our country has. And obviously without a jury trial cannot exist. So again, I thank you for your service, and I'm just going to ask for your patience for a little bit longer as you listen to me, listen to instructions, perhaps listen to Ms. Powell if she chooses to do a rebuttal, and to then consider all the evidence before you. I think it's very apparent that throughout the course of these proceedings, my client has been less than truthful. Not going to sugarcoat it, she's a liar. I think it is apparent that she lied in October and November of 2014 when she was first met by law enforcement. It's apparent that she lied when the home was being searched in March of 2015. It's apparent that she lied to the FBI when she met with them in late 2015. There may be parts of when she was talking to Detective Cochran that you may not believe and that wherein she was less than truthful. You might not even believe her when she was sitting in that chair right there and testifying on Friday and yesterday. She's admitted numerous times to lying throughout this. The question becomes then, how can we believe her when she's telling a version of events that she knew that Jason was going to kill Chris? How can we believe her when she says that she was a willing participant in the cover-up? And how can we believe her when we hear this talk of her being a serial killer? I say we can't. Now, if I was to lie to you on Monday and come back to you on Tuesday and lie again, and come back to you on Wednesday and lie, tell you the same lie, or tell you a lie on Thursday, why on Friday would you believe what I have to tell you? What was it that for those 3 weeks that Ms. Cochran was making herself look guilty that makes her any more or less believable than any of the other times that she was telling a version of the story? What's so special about those times? I say nothing. A liar is a liar. I think it's safe to say that anything that Ms. Cochran tells you should be looked at with skepticism and great scrutiny. And I think if you do that, looking here, you'll see that the only evidence that the people have to get to their burden is the word of Ms. Cochran. No other evidence. Now you saw Ms. Powell's closing. She gave you the elements. Again, don't focus on those. We'll talk about those a little bit more down the road. I'll instruct you on those. But she was giving me supporting evidence. She put some little check marks. I noticed that at least for the homicide charge. How many times did she say, when I say she, I mean Ms. Powell, that she, Ms. Cochran, said, or she told us, or she inferred? How many times during that time did we hear that was something to that phrase? I think it was many times. And again, that is the only evidence that they have here, is the word of Ms. Cochran. Now in my opening, I told you that my client gave a bit of a evolving story, and I'm not the only one who said that over the course of this. There's some times, and I took note of them, and other people, when they testified, made comments to that effect. Detective Ogden testified. He said something to the effect that this whole story is odd, and it was necessary to pick out pieces of the truth. Ms. Rizzo, when she testified, characterized this as a puzzle. I think that's a very good analogy. I think that this is a puzzle, and it remains a puzzle. I believe that Ms. Powell has brought the puzzle to you, opened the box, dumped that puzzle out on that table, and said, okay, folks, put it together. But here's the thing. I'm not going to show you the picture on the box for that puzzle. I'm going to tell you what that picture is. So we really don't know what this puzzle is supposed to be that you're putting together. Now again, we do have some indication. We have what Ms. Cochran has said. In her opening, Ms. Powell gave you 3 scenarios on a PowerPoint. Now, let me paraphrase paraphrase those scenarios. They were, first of all, we had nothing to do with it. Second is, Jason did it, I had nothing to do with it. And third of all, we acted together. Kelly at some point has told all three versions of that story. And I suspect in the beginning of this case, back in early October, November of 2014, any one of those was plausible. Now, as we've gone into the evidence, I would certainly concede that option 1 looks very unlikely. It leads us to options 2 and option 3. Kelly's gone back and forth between those options. Paula has chosen to believe that's option 3. Again, Miss Paula believes that for some reason, when Kelly made herself look most culpable, those were the times that Kelly was telling the truth. What other evidence do we have of that? Kelly can lie. Science can't. We've had a multitude of experts come in here and tell you what their tests have shown us. And can any of that science tell you that option 2, that Jason acted alone, is any more plausible than option 3? I'd argue that science can't tell you either way. Now, a skull was found. Kelly led the authorities to the skull. She shows us that she knew where that skull was left, generally. Implies that she knows how it got there. Or as to if it's option 2 or option 3, finding the skull itself doesn't tell you definitively what happened. Dr. John Filippi did tests on the skull. His tests tell us that with a reasonable degree of certainty, the skull that was found, in the field off Pintoga Trail was Christopher Regan. That's all you can tell us. Going to tell us how it got there. Going to tell us how long it had been there for. Going to tell us who put it there. For those answers, again, we have to turn to what Ms. Cochran said at various points during this process. Now, John Sabello came and testified over the video, and he can tell you that Mr. Regan died of a gunshot wound to the back of the head. Again, can't tell you where Mr. Regan was when he was shot. Can't tell you when Mr. Regan was shot. Cannot tell you who shot him. Again, for those pieces of the puzzle, we have to turn to Ms. Cochran. Ms. Cochran says that Chris was shot in the Cochran home. Is there any scientific evidence to back this up? Heard from Tiffany Smith, who's a champion, who did the DNA analysis on a plethora of items, tons of items. The only thing of note, that came back positive for Mr. Regan's DNA were the forceps found in the home. Now we heard Kelly tell how she used those forceps to dig, or attempt to dig, or make it look like she was digging the bullet out of Mr. Regan's brain. Does the DNA test tell you that's true? DNA test said that Mr. Regan's DNA is on those forceps. Doesn't tell you where, when, or how he made contact with those forceps. Forceps are mobile. While they're found in the Cochran home, there's no proof, other than Kelly's word, that Mr. Regan contacted those forceps in the Cochran home. There's no proof, other than Ms. Cochran's word, that those forceps were used for that terrible thing that she described. Finally, assuming that you believe those forceps were used to look for a bullet that is in Mr. Regan's brain, forceps can't tell you the circumstances behind that. They can't tell you whether or not Jason was standing there with a gun, literally or proverbially, over Kelly's head, telling her to do so. Well, the DNA can tell you a lot. Cannot fill in the missing pieces of the story. Again, we have to look to what Ms. Cochran has said. Now, there are some other items that were found as well that had DNA in them. I don't think any of them had any major significance. But none of them could also tell you that Mr. Regan had ever set foot in the Cochran home. We can infer that. We can look at the post-it note. Had directions leading from his house, basically, to his apartment, I should say, to the Cochran home. But is there any proof that when he got there, he ever entered the home? Again, while the forceps can certainly lead to that inference, they are mobile. They are not a fixture. They are not a floor. There was a floor that allegedly was colored with blood. They are not a wall. There's no scientific evidence to say that Mr. Regan definitively entered that home. Again, there's no fingerprint evidence to show that. There's no eyewitness testimony other than that of Ms. Cochran. The only way that we would suspect he'd been there is hearing from her. Now, we also heard about what Mr. Kahn told us about his GPS unit in his car. Indicated that around 5:25 on October 14th, that vehicle was at the Lawrence Street address in Caspian near the Cochran home. Again, GPS doesn't tell you how it got there. It doesn't tell you who was driving. Certainly there are some logical inferences. GPS doesn't definitively tell us anything. It doesn't tell us that Mr. Regan got out of the car. It doesn't tell us he entered the home. The analysis simply shows that at around 5:25 in the afternoon, October 14th, 2014, for whatever reason, Mr. Regan's car was near the Caspian home. The same can be true for the readings that were taken later that day, at about 8:17, when the vehicle was on Ice Lake Road, and around 8:27 when it was at the carpool lot. Again, science tells you where the car was. Nothing more. Can't tell you who was driving, who was in the car, or why the vehicle was at a particular location. GPS cannot tell you what was going on in that car. Now, talking about those times, I also want you to consider the testimony of Ms. Maitek. She said that when she heard this incident outside the home, it happened after 11 o'clock at night. The times I gave you were, again, 5:25, 8:17, and 8:27. At 8:27, according to GPS, the vehicle was over at the carpool lot. That's a heck of a lot earlier than 11 o'clock. Chris had a rabbit's foot that he carried with him as a good luck charm. While a rabbit's foot was found at the Cochran home, it is said that this rabbit's foot looked like the one that Chris may have owned. There's no scientific evidence, again, saying that this is that rabbit's foot. There's no comparable DNA on it. Science cannot tell us that it is for sure how long that rabbit's foot had been there or how it got there. Further, there is no scientific proof that the Cochran home was the scene of any crime, let alone the crime that's been described here. Leslie Larson told us about the search of the home in late August and early September of 2015. All kinds of presumptive tests were done. Again, these presumptive tests are subject to false positives. Metal, rust, cigarette smoke, and of all other things, horseradish seem to cause these false positives. Presumptive tests cannot tell you definitely if the blood is human or not. Could be human, could be animal blood. Presumptive tests can't tell you the circumstances that the blood got there. Can't tell you how long you've been there. Again, while there may be some inferences that there is some potential blood at the home, it doesn't tell you whose it was, how it got there, or why it was there. Could have been something bad, as Kelly described, or it could be something completely innocent, as someone at one point cut themselves in their home. I'm sure you've all cut yourselves at your home. Again, science can't fill in those details. Now, Ms. Grizz also told you about these cadaver dogs that went to the Cochran home. She told you that there were no hits by this dog or these dogs in the basement of this home. The basement is where this body, Mr. Regan's body, was allegedly dismembered into numerous pieces sufficient to fill 15 garbage bags. If we are to believe that that's where Mr. Regan was cut up, I can't imagine how there would not be some kind of scent for those dogs to hit on. Again, Ms. Paul will tell you that Kelly took some forensic classes. I think the testimony from Mrs. Cochran was she took a semester. Must have been one heck of a class that you can clean up that good with that much blood that I would presume to be there. I think Ms. Paul used the term bathed in blood during her closing. Must have been one heck of a class. And again, this is a confined area. These are dogs that are trained. They had their nose literally to the floor. Get no hits. These also dogs that you can take out in a canoe or a kayak that can hit something underwater. Get in that basement, no hits. They're worse than hits outside the home. Again, these hits provide little information as to when, where, why, how. Now we have these hits also over in Florence County. Remember I asked Chief Rizzo about that? And she said that dogs reacting that way could be from something that happened years ago. Traffic fatality that happened 20 years ago may trigger these dogs. Again, just because there's a hit outside the home doesn't tell you when, why, or how. They said that at some point there's potentially a human body there. Could have been from years ago. Could have been from a previous owner. We don't know. Same can be said for these presumptive tests of the Cochran truck. Again, can't tell you if there's blood there, if it's human or animal. There's no scientific proof that Chris Reagan's blood was in that vehicle. Now, Kelly is giving you an alternative version of what happened. She told you that she went hiking with Chris, cut himself. They went hiking, I think she was very specific about this. Went hiking at Lake Ottawa, and you were on the light blue trail. Again, is there any proof that this scenario didn't happen? Here, this fellow wants you to pick and choose kind of when it's time to leave Miss Cochran and when it's not. When it helps fill in the gaps, when it helps the case, when it helps get a conviction, well, then Kelly's telling the truth. But if it doesn't, that's when Kelly's lying. Can't have it both ways. Kelly did lead the police gun in the Caspian pit. She told them again generally where it was going to be. Again, it shows you that she knew something about the incident. Doesn't tell you if she was the one who participated in the incident or not, or if she knew in advance what Jason's plans were for Mr. Regan. Just simply tells you that she knew where the gun would be. Trooper Heslin, who found the gun, can't fill out that information for us either. Like finding the skull, finding the gun, just tells you where it was. Doesn't tell you the rest of the story. Nor can James Buck. He can tell you the model, he can tell you the make, he can tell you that the gun had been, the serial number of the gun scratched off. That's about it. Can't even tell you that that particular gun that they found in that pit, or the part of the gun I should say, that they found in that pit was the weapon that killed Mr. Regan. Again, the only tie that we have to that weapon, to that crime, is Kelly's word. Now, also found in this Caspian pit was a burn barrel. Actually, if I remember correctly, I think 2 burn barrels were found. No idea who either one of these belonged to. Now, you heard the Cochrans had a burn barrel. We don't know where it's at. Can't find it, can't explain where it's at. But again, there's no definitive proof that that burn barrel, either burn barrel, was the one from the Cochran home. Here we can't even turn to Kelly, because again, I believe it's her testimony that she doesn't even know where that burn barrel went. So again, we have a burn barrel that was found, that's all we know. Now you've heard a lot about texting and telephones and towers and sites and sectors. And a lot of things can be looked at and data analysis of data can happen here. But looking at these, we look for patterns and they make guesses about what was going on. They looked at the phone discussions between Kelly and Jason on October 13th, and they could say, well, things increased. The communication between them increased. Don't know why. They just say it increased. Again, you can review the text, and I hope you will take time to look at the text while you sit in the jury room. The text between them were back and forth about various things. I didn't see any kind of nefarious plan being cooked up on the 13th. Kelly tells you that Jason was in the hospital that day, and that she was communicating with him to make arrangements to pick him up and to deal with what he needed to deal with. Why is that explanation any less plausible than the explanation that Ms. Paul wants you to believe that they were plotting and planning? Again, there is no proof that they were plotting and planning, and perhaps the phone discussions were something simple as I just told you. Now, Mr. Collinsworth can also tell you that where a particular phone was at a particular time, to some degree. So I understand it. Again, I'm not an expert at this. He can tell you that this phone was tied to a particular site or a particular tower and within a particular sector. So 1/3 of a radius around that tower, that phone was there. I don't believe they could narrow it down any further when you're looking at texting and telephone calls. Can't tell you who had the phone. Can't tell you what they were doing with the phone other than they were texting or talking. Unless we have independent records telling what the text said, we don't know. We don't have records of those phone calls, we don't know what was being said. A lot of people, phone is something like an appendage to them. However, phones can be left, they can be forgotten, other people can borrow them. We don't know what was going on with those phones other than where their location was. Well, the NELO system can tell us a bit more. It too had a margin of error. October 24th, 2014, Jason's phone was pinging within a 300-meter radius in an area about 1 mile from where the skull was found. Put his phone there. Not necessarily him. We don't know. Can't tell what he was doing there or why he was there, if it was there. Now, if you remember, if you look at where that circle was, I think it was up here even today. That's pretty darn close to the highway. There's potential that that's what he was on, what he was doing, just simply riding by. We don't know. We don't have the answers to those questions. Now again, there are other pieces of evidence that you've seen. You've seen the video from Holiday, you've seen the video from First American Bank, you've watched them. You have to decide if you believe that truck was Miss Cochran's truck in that Holiday video. You have to decide that person with the First American Bank cab was Miss Cochran. If you do believe that was the truck and it was Miss Cochran, again, does that really narrow down between options 2 and option 3? Again, option 2 is Jason did it. I didn't know it was going to happen. And option 3 is we act together. Either of those videos give you that answer. I'd submit it doesn't. All it shows is the vehicle driving on the highway towards the American. All it shows is someone who looks like Kelly entering that apartment. Doesn't give us the answers here. I would submit that none of the science can help us determine the truth here. And that's what this whole endeavor is about, determining the truth. None of the scientific evidence can really definitively say if it's option 2 or option 3. For that matter, why are there only 3 options? Again, those are what Kelly told us. We don't know that there could be other options out there. I'll ask you this, and again, it's a bit out there, but is there any evidence, scientific evidence, that this crime, that Mr. Regan was even shot in this county? There's Kelly's word. None of the evidence can tie him down to Kelly's apartment, or house, excuse me. Just simply tell that we have Kelly's word to that effect. That's it. That's not enough. What's her word worth? She's a liar. She's admitted to lying numerous times in the course of this investigation. She lied from the get-go and lied throughout. Again, you might not have believed her when she was up on this stand. That's your prerogative. You have the right to do that. But again, why is she truthful when she says she is acting with Jason versus the times that she said he acted alone? What makes her more truthful then? According to Detective Ogden, it would fly against logic for her to say that. In his witness versus the suspect scenario, he said, the person usually picks a scenario that makes them the least culpable, and they usually do that pretty quick. She didn't do that pretty quick. It took a while. And now she's told a story where she is more culpable. Again, why? She's explained it to you. She's told you. It's up to you to believe her. If you believe that she's a liar, that's fine. But again, how can we pick and choose when she's lying and when she's not? And you might not like the fact that Kelly lied. Might want to punish her for it. That's fine. There's a potential charge for that, and you can find her guilty of that charge, which is called lying to a peace officer or something to that effect. I want to point out, though, she's not the only one who's lied in the course of this investigation. Jason lied. Ms. Rizzo indicated that she was deceptive to Kelly to try to gain her trust. Detective Ogden lied to Kelly. Detective Ogden, Walt Hamerman, cooked up the scenario about this letter. There's been a whole lot of lying going on here, folks. Doesn't excuse Ms. Cochran's lies. In fact, it may make her guilty of a crime, the fact that she lied. That crime isn't homicide. Again, there is no scientific proof that Kelly was a willing participant in that homicide and that she participated in the cover-up willingly. Ms. Cochran has told you her alternative version of events. Again, I've been calling that option 2 throughout this argument here. Summing it up, it's Jason acted alone in the killing, without Kelly's knowledge or consent. She told you how she was shocked and horrified when Jason killed the man that she loved. She told you about the dismemberment, disposal, and cover-up of Chris's death. She feared for her own safety. She told you that Jason would find a way to kill her if she did not participate in this cover-up. Again, how much of that you choose to believe is up to you. Burden is not with me to prove anything to you, folks. The burden's with the prosecutor. I presented an alternative theory. I don't have to prove it beyond reasonable doubt. Theory only need be possible. Again, under this theory, Jason acted alone to kill Chris without Kelly's foreknowledge and approval, and any part that Kelly played in the cover-up was under duress. Again, there's evidence, that this is plausible. First, there's Kelly's word. Again, I'm stalking on that, it's up to you. Let's also look at Jason. It's very clear that Jason was not okay with Kelly having affairs, was jealous to the point of self-destruction, potentially harm to others. While he told the officers that he was fine with the affairs and that he was pretty much just going with the flow, he was a liar too. What were the first words that came out of his mouth in this investigation? They were lies. He was asked, "Is Kelly home?" "No, but she'll be back in about an hour," or something to that effect. His actions and demeanor with law enforcement had law enforcement concerned about Kelly's safety. I want you, when you get back to that jury room, if you're so inclined, to review the transcript from October 28th, 2014. When Kelly was talking to Troopers Ballinger and Brackett, Trooper Ballinger told Kelly, "I'm very concerned about the threats of violence. You know, this isn't something that happens on a regular basis, where someone threatens to kill you or themselves. And I guess that kind of behavior concerns me. I'm very concerned about your safety." That was echoed by Trooper Brackett, who alluded to the fact that it's possible that Jason killed Chris because, quote, "husbands get jealous," unquote. We've also heard about how Jason happened upon Chris's apartment, and lo and behold, there he sees the family vehicle as he's just walking through town. Heard about how as he's walking home, he walked with his head down and thought about jumping off a bridge. Again, does that sound like someone who was okay in his wife's affairs and just going with the flow? We also heard from Kelly about the potential of there being a GPS unit on the family vehicle. Well, again, there is no direct proof of this. There were searches from GPS websites that were done on the Cochran computer. Kelly denies that she did those searches. He also heard, I believe this is testimony of Ms. Rizzo, that when Jason would walk through town, he would keep an eye out for Kelly's vehicle. Again, does this sound like someone who was okay with his wife having an affair? Or from David Saylor, who said that Jason was heartbroken by Kelly's affairs. And finally, most notably, you've heard Jason's own words. And these are from the text that he sent. I believe I had Ms. Rizzo read them. And they're from Joint Exhibit 26, I believe. July 27, 2014. "Maybe if you loved me ever, you would have acted like my wife and put me before the things that you do that hurt me." It's September 9th, 2014, there's an allusion that Jason's going through Kelly's belongings. She says, "Quit going through my shit" to him. Certainly leads to the inference that he'd been going through at least her phone or who knows what else. Around that time, he also confronts Kelly about where she's been, saying to the effect that you lied about having an appointment with Dr. Klein. And most notably, September 16th, 2014, "Please don't go to those apartments. You are married. That was not the first time that you were there. Please come home after work so I don't have to come find you. I do not want to have to knock on doors, and you know I will." Jason himself alluded to the fact that it made sense for law enforcement to look at him, as he was, quote, "the jealous husband." The question is, did Jason act alone in this killing? Or did Kelly act with them? And again, there is no evidence either way. While Kelly was late about telling law enforcement about Jason's violent nature, she did tell people. She told Eric Erickson, who questioned her why she'd be in such a relationship. She talked to Laura Sartori about Jason and his mental conditions and his violence. In fact, I remember Ms. Sartori even saying, "I wanted to take her into my home," or something to that effect, or she would have allowed Kelly to stay with her. Certainly, I think that does show a grave amount of concern for Kelly's safety. While she did take a while to tell people about it, she has made these disclosures. No doubt, Jason had mental health issues. There's medical records that confirm this. Again, I encourage you to take a look at those medical records. Those are the joint exhibits that we marked yesterday. I think they were 117 through 122, something like that. Most of them said that Jason was suicidal. They didn't say homicidal. But again, there's no argument, and I think it's the state's case, that Jason was the trigger man. Obviously shows he's homicidal if he was willing to pull the trigger and shoot someone. He was obviously homicidal enough to kill Chris Regan. And again, there was no contention that it was not him that pulled that trigger. Kelly's told stories about Jason killing other people. Again, none of that talk's panned out. You've seen the outline for the book, be it autobiographical or not. I think it speaks for itself. Jason's not about homicide. The question for you is, again, did Kelly know that Jason was in the basement on October 14, 2014? And you also need to decide if Kelly was so scared of her own life that she had no choice but to assist Jason in dismemberment, disposing of Chris's remains, and then lying about it. Again, there's no sign to say that that scenario is any more or less likely than saying that Kelly acted together. I find it interesting that Paul kind of alluded to the fact that, well, you heard from these experts saying, you're not always going to find DNA, you're not always going to be finding blood, you're not going to be finding fingerprints. Had they found something, do you think she'd be saying that? Obviously not. She'd be trumping it from the rooftops. Again, the fact that it's not there doesn't indicate necessarily that Kelly was good and she cleaned it up. Could be that there simply was no proof that anything even happened. Again, I don't have to prove this theory to you. I have to present some evidence that's possible. Ms. Powell is actually charged with disproving me. She has to disprove that Kelly was not. She has to prove to you that Kelly was not acting under duress. I know it's kind of a confusing way to put it. She has to disprove this alternative theory. Again, she hasn't done so. In a moment, you're going to be deciding Kelly's fate. Again, you're here to consider certain things, but there are things you're not here to consider. You're not here to judge her on her lifestyle choices. A lot of people take their marriage vows very seriously and are offended by those who have extramarital affairs. If you feel that way, it's certainly your right to do so. Again, we aren't here, though, judging Kelly on her adherence to her marital vows and her faithfulness to Jason. Also not here judging if she's a drug user or not. Again, she says she is. However you may feel about that, she's not here for any kind of drug crime. Again, you might simply not like Ms. Cochran for whatever reason. You might not like her language, you might not like her perceived demeanor while she was on the stand, perceived lack of emotion. That's your prerogative. But again, you have to put your personal feelings aside, and you are charged with deciding certain things. Another thing that you're not here to decide is the shanks that we've heard a lot about. Again, I believe those were brought to your attention to try to show that, well, gee, she made these, she must be a violent person. If you consider that, I want you to consider the conditions in that jail in Kentucky. You've heard about them. You heard how she's locked in a room with very little to do. You heard how people are coming about every 10 minutes to check on her. So I want you to consider that when you consider these shanks. Also, most importantly, I want you to consider these events happened in a different state 18 months after the crime that allegedly happened here. So we aren't here to judge her on these shanks. If Kentucky wants to deal with that, that's up to them. It's not for us. You are here today to determine whether or not you believe that Kelly participated in the killing of Mr. Regan. You are here today to determine whether or not Kelly's participation in the cover-up was out of fear for her life and safety. Remember in my opening, I told you that a trial is like putting a little weight on each side of the scale of justice. You've seen the picture, I talked about it. It's time for now, each of you, to decide how much weight each witness puts on the appropriate side of that scale. Again, I ask you not to only look at what they said, but the background behind their statement. I think I gave you that example of the iceberg when we first started this. I want you to look not just the tip of the iceberg, but all of it. I want you to look again at what's going on when a particular statement was made. I want you to consider whether that person was susceptible to something or potentially under the influence. Again, I respectfully ask that you try not to only consider what was said, but to ask yourselves potentially why was something said. You've heard the evidence. It's time to assign the weights. You put on one side of the scale or the other. Again, there are numerous potential versions of events. So Paul will tell you one version. Again, I'll say that version has not been proven other than the word of Miss Cochran. You have to decide how Miss Cochran's word affects that scale and how much weight you should put there. Again, I'd suggest that Miss Cochran shouldn't be budging that scale all that much. She's a liar. If you disagree with me and believe that perhaps her word tilts that scale towards the prosecutor, you have to decide how far that scale is weighed down. Now, I can see that the scale does not need to be weighed 100% down, but should be pretty darn close to it. That is the people's burden. It's a burden that they have to meet. And again, we've promised to hold them to their burden. Today to show you evidence that Mr. Regan was shot in the back of the head. To show you that Chris was found in the woods, his skull was found in the woods. That's about it. That's all that the science can really tell us. As to who shot him, how he got there, we have the word of Miss Cochran. Again, numerous versions have told that story. None have been proven. There's still a reasonable question as to what really happened to Mr. Regan. If you remember correctly, I don't know if you noticed it, but I think I saw it on one of Mr. Niger's posters. There's a website, What Happened to Chris, or something to that effect. We are no closer to answering that question today than we were when that poster was made. We don't know. We cannot know. We've been told, but we have no proof. There's still reasonable questions to that story. And a reasonable question equals a reasonable doubt. In closing, I want to talk to you about an old story. There's a story that when you hear hoofbeats out somewhere, perhaps in the hallway out in that lobby, you should be thinking that it's a horse and not a zebra. Basically means don't go be looking for something that's rare. So Paula wants you to look at this case and see a zebra. She wants you to believe that Kelly's a violent person who joined to a pact with her husband. to murder Chris Regan. Again, she's used that term several times, bond and blood. There is no proof of this. If you hear the hoof beats here and it turns out to be a zebra, certainly would be a lot more interesting story as well than would it be a horse. Kelly were a serial killer, be a lot more of an interesting story. Folks with those cameras over there are probably kind of hoping for that kind of story. It's probably why they're here. Fortunately, again, there is no proof of this. You hear these hoof beats, you should think the most obvious thing. You should not be searching for wild scenarios. Detective Ogden went further. He heard the hoof beats, and not only did he see a zebra, he saw a unicorn. A unicorn, folks, is a thing of fiction. There is no proof that Kelly's stories, any of them, are anything but fiction. I also believe it was Detective Ogden who said that you have to look for the nuggets of truth in what Kelly says. That isn't what's supposed to happen here. The puzzle should not be dumped in front of you and say, okay, folks, figure it out. It's not the people's burden. People's burden is to tell you what happened. They cannot do so. There is reasonable doubt here. We only have Kelly's word as to what happened to Chris. Kelly's a liar. I would argue that if someone's a liar, it's foolhardy to believe that for some period of time, they're slightly telling the truth unless there's something to back up that truth. There is not. As such, I'd ask that you consider all this, take a look at the evidence, and I think after you do so, you'll see people have failed to meet their burden. And if you believe that, you have to acquit. Thank you.
Thank you, Mr. Shelby, members of the jury. Because the people have the burden of proof in this matter, they have a right to come before you and give what's called a rebuttal argument for new matters raised by the defense. Ms. Powell, do you have a rebuttal argument?
One page. I'm going to bullet point it for you. I'm going to bullet point it for you. I know this has been a long couple weeks. Number one, the admissions and the confessions in Kentucky were taken when the defendant was incarcerated. That means she's unable to blame the drugs or any other reason for providing those statements. Number two, she blamed her other statements on drugs, on being high or under the influence of drugs. Number three, there is no doubt that we never would have found Chris Regan unless something urged the defendant to talk. We wouldn't be here if she hadn't started talking. And she hadn't started talking. The first time she talked was March 29th. Number four, the judge is going to give you an instruction on what direct evidence is and circumstantial evidence is. He's going to tell you that testimony from this witness stand is evidence, and that you are allowed to make any reasonable inference you want from that evidence. Such as, if there's Chris's DNA on the forceps, it's reasonable to assume that her statement that she said she dug the bullet out of his skull with the forceps is reasonable. Number five, with Kelly Cochran, it has been a game. It's been a game the entire time. Detectives have had to try and separate the breadcrumbs of lies from the breadcrumbs of truth. Number six, the defendant had the opportunity to tell you why she claims she lied in Kentucky. Her explanation doesn't make sense. Her explanation defies logic. Number seven, sometimes a zebra is a zebra. Number eight, let's flip this puzzle analogy on its side. Mr. Schulke, the defense is telling you that the prosecution's brought you a box full of puzzle pieces and dumped it in front of you and told you to put it together. Well, ladies and gentlemen, when you put a puzzle together, it starts to take shape of a picture. And as you look at this picture, you start to understand what this picture is. So as you complete half the puzzle, you see Mona Lisa's cape. You see Mona Lisa's hair. As you complete 3/4 of the puzzle, you see Mona Lisa's cheek and the color of her shirt or her dress. As you complete 99% of the puzzle, you see the picture. You see Mona Lisa's smile. But you might be missing one piece of puzzle from her hair. But you know exactly what that puzzle picture is. You know that it's Mona Lisa. Ladies and gentlemen, what we have here is a puzzle of Kelly and Jason Cochran killing Chris Regan in concert.
Thank you, counsel. Members of the jury, the evidence and the arguments in this case are finished, and I now will instruct you on the law. That is, I will instruct you on the law that you are to apply in this case. Remember that you have taken an oath to return a true and just verdict, based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all of the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all of my instructions together as the law that you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. Now, I've instructed you before, and I will do so again. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial. It entitles the defendant to a verdict of not guilty, unless you are satisfied, beyond a reasonable doubt, that she is guilty. Now, every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Now, a reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Now, let me define for you what evidence is. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things that the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions, likewise, to the witnesses are not evidence. My questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. Now, at times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence. But you should not use any personal knowledge you may have about a place, a person, or an event. To repeat once more, you must decide this case based only on the evidence admitted in this trial. Now, let me instruct you on judging the credibility of witnesses. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any witness's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you might have based on gender or national origin of the witness. Now, there is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions and argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, other influences that affected how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? Now, sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought, they saw, or remembered. It is also a good idea to think about which testimony agrees best with the evidence of the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept that part you think is true and ignore the rest. Now, you're going to be hearing about less serious crimes. I'm going to be instructing you on open murder count, which is count 1. And in that count, and I'll explain in a little more detail later, there is first-degree murder and second-degree murder. Second-degree murder is a less serious crime contained in the open murder charge. Now, the prosecutor must also prove beyond reasonable doubt that the crime occurred on or about October 14th of 2014 through May 31st of 2016 in Iron Common. Now, possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. Possible penalties should not be considered by you. Now, the prosecution has introduced evidence of a statement that it claims, or statements that it claims the defendant has made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all of the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Now, facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that is circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all of the evidence that you believe. Now, there has been some evidence that the defendant ran away after the alleged crime. This evidence does not prove guilt. A person may run or hide for innocent reasons, such as panic, mistake, or fear. However, a person may also run and hide because of a consciousness of guilt. You must decide whether the evidence is true, and if true, whether it shows that the defendant had a guilty state of mind. With respect to motive, you may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the crime, only as to show that the defendant actually committed the crime and that she meant to do so. Now, there's been some evidence introduced in the course of this trial to show that the defendant committed improper acts for which he is not on trial. If you believe this evidence, you must be very careful only to consider it for certain purposes. You may only think about whether this evidence tends to show A, that the defendant had a reason to commit the crime, B, that the defendant specifically meant to aid and abet Jason Cochran, C, that the defendant acted purposely, that is, not by accident or mistake or because she misjudged the situation. That the defendant used a plan, system, or characteristic scheme that she had used before or since, and finally, who committed the crime that the defendant is charged with. You must not consider this evidence for any other purpose. For example, you must not decide that it shows that the defendant is a bad person, or that she is likely to commit crimes, You must not convict the defendant here because you think she is guilty of other bad conduct. All the evidence must convince you beyond a reasonable doubt that the defendant committed the alleged crime, or you must find her not guilty. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts and circumstances involved in the case. Now, you should not decide this case based on which side presented more witnesses. Instead, you should think about what each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and the evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer or a lawyer's representative talked to one of the witnesses. There is nothing wrong with this. A lawyer or a lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You have heard testimony from a number of expert witnesses who have given you their opinion in their field of expertise. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts he or she gave for her or his opinion and whether those facts are true. You should also think about the expert's qualifications and whether his or her opinion makes sense when you think about all of the other evidence in the case. You have heard from a number of police witnesses. The testimony is to be judged by the same standards you would use to evaluate the testimony of any other witness. Now, in this case, the defendant is charged with committing open murder, that is first-degree premeditated murder or second-degree murder, or intentionally assisting someone else in committing it. Anyone who intentionally assists someone else in committing a crime is as guilty as the person who directly commits it and can be convicted of that crime as an aider and abettor. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the alleged crime was actually committed, either by the defendant or someone else. It does not matter whether that anybody else was convicted of the crime. Second, that before or during the crime, the defendant did something to assist in the commission of the crime. Third, at the time, the defendant must have intended the commission of the crime alleged, or must have known that the other person intended its commission, or that the crime alleged was a natural and probable consequence of committing the crime intended. It does not matter how much help, advice, or encouragement the defendant gave. However, you must decide whether the defendant intended to help another commit the crime. And whatever her help, advice, or encouragement actually did help, advice, or encourage the crime. Even if the defendant knew that the alleged crime was planned or was being committed, the mere fact that she was present when it was committed is not enough to prove that she assisted in committing it. Now, the defendant is charged, as I said, with first-degree murder, aiding and abetting. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that Jason Cochran caused the death of Christopher Reagan. That is, that Christopher Reagan died as a result of the gunshot wound. Second, that Jason Cochran intended to kill Christopher Reagan. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means that Jason Cochran considered the pros and cons of killing and thought about and chose his actions before he did it. There must have been real and substantial reflection for a long enough period of time to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. Fifth, anyone who intentionally assisted someone else in committing a crime is as guilty as the person who directly commits it and can be convicted of that crime as an aider and abettor. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the alleged crime was actually committed, either by the defendant or someone else, and it doesn't matter whether that someone else was convicted of the crime. Second, that before or during the crime, the defendant did something to assist in the commission of the crime. Third, at the time the defendant intended the commission of the crime alleged, or must have known that the other person intended its commission, or that the crime alleged was a natural and probable consequence of the commission of the crime included. Now, as I said, I'm going to have a verdict form to help you walk through these concepts, but this open murder charge of count 1 includes a premeditated murder. It also includes second-degree murder. I'm going to now define for you this lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that Jason Cochran caused the death of Christopher Reagan. That is, Christopher Reagan died as a result of the gunshot wound. Second, that Jason Cochran had one of these three states of mind. Either he intended to kill, or he intended to do great bodily harm to Christopher Reagan, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. Third, anyone who intentionally assists someone else in committing a crime is as guilty as the person who directly commits it and can be convicted of that crime as an aider and abettor. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the alleged crime was actually committed, either by the defendant or someone else. And again, it doesn't matter if that anyone else has been convicted of the crime. Second, that before or during the crime, the defendant did something to assist in the commission of the crime. Third, at that time, the defendant must have intended the commission of the crime alleged, or must have known that the other person intended its commission, or that the crime alleged was a natural and probable consequence of the commission of the crime intended. Now, it's alleged in this case that the killing was done willfully and with premeditation and deliberately by lying in wait. Lying in wait means that Jason Cochran hid himself, planning to take another person by surprise. While lying in wait, Jason Cochran must have intended to kill Christopher Reagan. The lying in wait must have lasted only long enough to show, beyond a reasonable doubt, that the killing was done willfully, with premeditation, and deliberation. Now, when I talk about these states of mind, you must think about all of the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. You may infer that the defendant, or Jason Cochran, intended to kill if a dangerous weapon was used in a way that was likely to cause death. Likewise, you may infer that the defendant, or Jason Cochran, intended the usual results that follow from the use of a dangerous weapon. And a gun is a dangerous weapon. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. Premeditation and deliberation may be inferred from any actions of the defendant or Jason Cochran, which show planning, or from any other circumstances surrounding the killing. The prosecutor need not prove a motive for the killing, but you may consider evidence of motive in deciding if there was premeditation and deliberation. Motive by itself does not prove premeditation and deliberation. Now, if you find the defendant is guilty of murder, you must state in your verdict whether it is murder in the first degree or the second degree, and this verdict form will walk you through that. Now, the verdict form also contains the status of accessory after the fact. The defendant is charged in the alternative with being an accessory after the fact to open murder, that's first degree premeditated, or second degree murder. An accessory after the fact is someone who knowingly helps a felon avoid discovery, arrest, trial, or punishment. To prove that the defendant is guilty, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that someone else committed the open murder, first degree, premeditated, or second degree. The elements of the first degree premeditated murder in this case are listed in the previous instruction which I gave you. The prosecutor and the elements of second degree murder are also defined in the previous instruction. The premeditated is 16.1 and the second degree is 16.5. The prosecutor does not have to prove that the other person has been charged with or convicted of open murder, first degree or second degree. She just has to prove that open murder was committed. Second, that the defendant helped the other person in an effort to avoid discovery, arrest, trial, or punishment. Third, that when the defendant gave help, she knew the other person had committed a felony. Fourth, that the defendant intended to help the other person avoid discovery, arrest, trial, and punishment. Now, I've instructed you on the aider and abettor statute and the accessory after the fact instruction. Let me explain the difference between those two. You must decide if the defendant is guilty of open murder, first or second degree, as an aider or abettor, or is guilty of being an accessory after the fact to the felony open murder, first degree, premeditated, or second degree, or if she is not guilty. If the prosecutor has proven beyond a reasonable doubt that before or during the open murder, first or second degree, the defendant gave Jason Cochran encouragement or assistance intending to help him commit that crime, then you may find the defendant guilty of aiding and abetting that crime, that is murder. If the prosecutor has proven beyond a reasonable doubt that the defendant knew about the open murder, first degree or second degree, and helped the person who committed it avoid discovery, arrest, trial, or punishment after the crime ended, then you may find the defendant guilty of being an accessory after the fact. The felony of open murder ends when Christopher Reagan died. If the prosecutor has not proven either of these charges beyond a reasonable doubt, your verdict must be not guilty. Now, this verdict form charges in count 1 open murder, and it goes on to list an additional 4 more counts. And I'm going to review those with you now. Count 2 is the larceny in a building offense. The defendant is charged with the crime of larceny in a building. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant took somebody else's property. Second, that the property was taken without consent. Third, that the property was taken in a dwelling. Fourth, that there was some movement of the property. It does not matter whether the defendant actually kept the property or whether the property was taken off the premises. Fifth, that the property was worth something at the time it was taken. And sixth, that at the time the property was taken, the defendant intended to permanently deprive the owner of the property. Now in count 3, this is the conspiracy to commit dead bodies, disinterment, and mutilation. The defendant is charged with the crime of conspiracy to commit disinterment, mutilation, defacement, or carrying away of a human body. Anyone who knowingly agrees with someone else to commit the disinterment, mutilation, defacement, or carrying away of a human body is guilty of conspiracy. To prove the defendant's guilt, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant and somebody else knowingly agreed to commit disinterment, mutilation, defacement, or carrying away of a human body. Second, that the defendant specifically intended to commit or help commit that crime. Third, that this agreement took place or continued during the period from October 14th, 2014 through May 13th, 2016. Now let me define the crime of disinterment, mutilation, defacement, or carrying away of a human body. A person not being lawfully authorized to do so, who shall willfully dig up, disinter, remove, or convey away a human or human remains thereof from the place where the body may be interred or deposited, or shall knowingly aid in such disinterment, removal, or conveying away, or shall mutilate, deface, remove, or carry away a portion of a dead body of a person, whether in his charge for burial or otherwise, whenever the mutilation, defacement, removal, or carrying away is not necessary in any proper operation in embalming the body or for the purpose of postmortem examination, then every person accessory thereto, either before or after the fact, shall be guilty of that felony. Now an agreement, when I say conspiracy, it's defined as an agreement in the coming together or meeting of the minds of 2 or more people, each person intending and expressing the same purpose. It is not necessary for the people involved to have made a formal agreement to commit the crime or to have written down how they were going to do so. In deciding whether there was an agreement to commit a crime, you should think about how the members of the alleged conspiracy acted and what they said, as well as all the other evidence. To find the defendant guilty of conspiracy, you must be satisfied beyond a reasonable doubt that there was an agreement to commit disinterment, mutilation, defacement, or carrying away of the human body. However, you may infer that there was an agreement from the circumstances, such as how the members of the alleged conspiracy met. The fourth offense is the concealing the death of an individual. The defendant is charged with violating the public health code. To establish the defendant's guilt in this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. The defendant discovered the body of an individual. The defendant knew or had reason to know that the individual was dead. The defendant failed to inform a law enforcement agency, a funeral home, or a 911 operator of the discovery of the dead body. If a law enforcement agency, a funeral home, or a 911 operator had already been informed of the discovery of the dead body, the defendant did not know about it, nor had reason to know about it, and the defendant failed to inform the authorities about the dead body with the purpose of concealing the cause of death. The fifth and, I believe, final count is entitled Lying to a Police Officer in a Violent Crime Investigation. The defendant is charged with the crime of concealing a material fact, making a false or misleading statement to a peace officer in a criminal investigation. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that Chief Laura Frizzle was a peace officer who was conducting an investigation of a criminal offense. Second, that the crime being investigated by Chief Frizzle was open murder. Third, that Chief Frizzle informed the defendant that she was conducting a criminal investigation. Fourth, that the defendant, A, concealed information relating to that investigation from the officer by some trick, scheme, or device. Using the trick, scheme, or device means acting in a way intended to deceive others. Or B, provided false information regarding that investigation to the peace officer in a statement that the defendant knew was false or misleading. And fifth, that the defendant acted knowingly and willfully. That is, the defendant concealed the information or provided the false information voluntarily and intentionally with the intent to deceive and not because of some mistake or other innocent reason. Sixth, that the information allegedly concealed or allegedly false information provided involved a material fact. A material fact is information that a reasonable person would use to decide whether to do. The fact is material if it has the capacity or natural tendency to influence an officer's decision as to how to proceed with the investigation. You may consider whether the officer relied on the information in deciding whether it was a material fact. However, it is not a defense to the charge that the officer did not rely on the information if you determine beyond a reasonable doubt that the defendant intended to conceal the information from the officer by trick, scheme, or devices of data or providing false information. It is not a defense to the charge that the officer was able to obtain the information from another source or by different means if you determine beyond a reasonable doubt that the defendant intended to conceal the information from the officer by trick, scheme, or device, or to provide false information. Now, there are certain defenses to lying to a police officer, and they include the following. The defendant says that the statute does not apply because the defendant's action was done under duress, because the defendant had a reasonable fear that she was in danger of physical harm from the defendant's spouse. If you find that the evidence raises a reasonable doubt as to whether the statute applies, then you must find the defendant not guilty. Now, what do I mean by duress? The defendant says that she is not guilty of conspiracy to commit disinterment or mutilation, concealing the death of an individual, or lying to a police officer, and being either an aider or abettor or an accessory, strike aider or accessory after the fact felony, because someone else's threatening behavior made her act as she did. This is called the defense of duress. The defendant is legally prohibited from arguing at trial that duress is a defense to the open murder charge. And you'll notice that the verdict form in all the other counts except count 1, open murder, and count 2, larceny in a building, contains a box where you can find her not guilty because of the reason. So that's right on the verdict form. But you will not find that in count 1. It's not a legal defense to murder. The defendant is not guilty if she committed the crimes under duress. Under the law, there was duress. 5 things were true. 1, the threatening behavior would have made a reasonable person fear death or serious bodily harm. B, or 2, the defendant actually was afraid of death or serious bodily harm. 3, the defendant had this fear at the time she acted. And 4th, the defendant committed the act to avoid the threatening harm. 5, the situation did not arise because of the defendant's fault or negligence. In deciding whether duress made the defendant act as she did, think carefully about all of the circumstances as shown by the evidence. Think about the nature of any force or threats. Think about the background and character of the person who made the threats or used the force. Think about the defendant's situation when she committed the alleged act. Could she have avoided the harm she feared in some other way than by committing the act? Think about how reasonable these other means could have seemed to a person in the defendant's situation at the time of the alleged act. Now, the prosecutor must prove beyond a reasonable doubt that the defendant was not acting under duress. If she fails to do so, then you must find the defendant not guilty. Now, there's been some evidence regarding a request for immunity that the defendant made to the authorities. This evidence should not be considered as substantive evidence as to the defendant's guilt, but may only be considered for the purpose of proving bias or prejudice of the defendant, to negate the contention of undue delay, or to prove an effort to obstruct a criminal investigation or prosecution. Now, when you go to the jury room, you will be provided with this written copy of these final instructions and this reference book, which contains not only the instructions but the verdict form and some relevant documents that the attorneys put together to put into the reference book. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agree on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and to make every reasonable effort to reach agreement. Express your opinions and the reasons for them. But keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you go wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. In this case, as I said, there are several different crimes that you may consider. When you discuss the case, you must consider the crime of first-degree premeditated murder first. It is the first item on the verdict. If you all agree that the defendant is guilty of that crime, you may stop your discussions and proceed to counts 2 through 5. If you believe that the defendant is not guilty of first-degree premeditated murder, or if you cannot agree about that crime, you should consider the less serious crime of second-degree murder. Now you decide how long to spend on first-degree premeditated murder before discussing second-degree murder. You can go back to first-degree murder after discussing second-degree murder if you want to. Now, if you have any questions about the instructions after you begin your deliberations, pass a note to the bailiff who will be seated right outside your jury room door. And he will take care of that communication. If you want to communicate with me on any other topic, when you are in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, the lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your verdict stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside of the jury room. Now, there have been over 100 exhibits in this case. If you want to see any of the exhibits, again, just ask the bailiff for them by way of a written note. You also, of course, can use your notebooks for those of you who have been taking notes during the trial. As I said, when you go to the jury room, you're going to be given this copy of these instructions. Your verdict form sets forth the fact that the defendant is charged with 5 individual counts, 1 through 5, with open murder being either premeditated or second degree, larceny on building, conspiracy to commit dead bodies, concealing the death of an individual, lying to police in a violent crime investigation. And under each, you're instructed that each one of these sections represents a separate verdict. And so you are to only check one box in each section. For example, under open murder, it's not guilty. Guilty of first-degree premeditated murder as an aider and abettor. Guilty of the lesser offense of second-degree murder as an aider or abettor. Or guilty of accessory after the fact to first-degree premeditated murder or second-degree murder. In count 2, larceny in the building, it's either not guilty or guilty of larceny in the building. In count 3, conspiracy to commit dead bodies, disinterment, and mutilation, it's either not guilty by reason of duress, or guilty of conspiracy to commit that offense. Count 4, concealing the death of an individual is not guilty by reason of duress, and guilty of concealing the death of an individual. And count 5, lying to a police officer, not guilty by reason of duress, or guilty of lying to a police officer. So in every offense where duress is a possible defense, it's listed on it. And again, it's the prosecution's burden to prove that the defendant was not acting under duress when she was committing these offenses. Now, we need to do something rather unpleasant. 2 of you are going to be stricken. We're going to draw your names out of this box. I've talked to jurors who were disappointed they were excused. I've talked to jurors who were very relieved they were excused. Before we draw your names, the 2 names of the individuals, please do not leave the courtroom until you give your phone number where you can be contacted by the bailiff. Give it to the bailiff. It's not that it never happens, but it sometimes happens where the 12 jurors who were not excused as alternates, one of them may become unable to continue with the deliberations, so we have to contact the alternate to come in, and you start your deliberations all over again from the start. So if you're struck as an alternate, again, don't discuss the case with anyone because you might be coming back into that jury room. We will let you know if the jury reaches a verdict. You'll be the first to know. And we'll have a way of contacting you to let you know that. Hopefully we won't have to have you come back in and start the deliberations over again. Let's see. Is the verdict form in the reference book?
It is, Your Honor.
Okay.
Your jury instructions.
Jury instructions. Okay, another thing. I'm, for once, telling you to start your deliberations and discuss the case among yourselves, but only among yourselves and only when all of your fellow jurors are present in the jury room. So if you're out on a smoke break and those folks that aren't, you're going to knock the discussions off until the smokers come back. Okay? Mr. Bailiff, would you step forward and take the bailiff oath? And just as a housekeeping matter, I guess we made arrangements to send out for voting.
Yes, sir. Once we're seated, we'll discuss that.
Okay. All right.
Do you solemnly swear that you will, to the extent of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or to any of them, orally or otherwise, that you will not communicate with them or any of them, orally or otherwise, except by order of this court, or to ask them if they have agreed upon this verdict until they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God.
I do.
Okay, now the alternates. When you walk by this courtroom, you might be approached by media or people just interested in the case. Again, please just tell them you're still on this jury and that you might be asked to come and serve, so do not discuss the case with anyone. All right.
Are you ready for me?
Yeah.
Christine Bruce, Penny Christine Bruce.
Bruce, and if you haven't been taking notes, there's a notebook in the jury room. Okay.
Jessica Ann Cook.
Thank you, Coach. Did you instruct them to leave?
What do that? Forward them?
The reference book, the ones in there, the verdict form, this is the official one. It has the four-person signature line. Members of the jury, I'm going to recess to deliberate and decide this case ultimately.
All rise.
Please be seated.